If you own property in Texas, or you're about to, there's a body of law that could affect your land in ways you never anticipated. It won't show up in the listing. It might not even be on the survey. But here's the thing. It can control what you build, who can cross your land, and what you can do about any of it. Today, we're talking about easements. And in Texas, this topic has its own rules. It has its own statutes, and it has its own case law. So what does that mean for you? Today, we map the whole thing out. Another day, another solution. Let's talk dirt. If you've watched our earlier videos, you already know what an easement is. You know appurtenant from engross. If you haven't seen those yet, you may want to start there first. I'll put the link below. Now we go deeper. Today is about Texas specifically, how this state approaches easements, and what the law actually says. And here's why that matters. This is not a topic where one size fits all. Texas has its own property code. Texas courts have their own decisions, and some of those decisions would surprise you. Here's what we're covering. The major categories of Texas easements, how they're created, what controls them, and what can end them. Think of this as your map before we take the deep dives. So let's start with the foundational stuff. Under Texas law, an easement is called a non-possessory interest in someone else's land. So Rick, what does that mean? Non-possessory means that you don't own the land. You have a right to use it in a specific way, even though you don't own it. Now that's simple enough, right? Well, here's where it gets important. The person or entity who benefits from the easement, that's what we call the dominant estate. The person or entity whose land carries the burden, that's the servient estate. Think about that for a second. One property benefits from the easement, and one property is burdened. Texas courts have been clear on this distinction for over a century, and it matters enormously when a dispute arises. So how does an easement come into existence in Texas? Let's start with the obvious one, the first one, an express easement. An express easement is a written document. It's signed, it's recorded in the deed records. The Texas Property Code requires that an easement affecting real property be in writing to be enforceable under what we call the statute of frauds. That is, unless an exception applies. And here's the thing, there are exceptions. Express easements are the clearest kind. You can read them, we can find them in the property records. You know exactly what was granted because it's written. But Texas law does recognize other ways easements can be created, and some of them have no document at all. The second type of easement in Texas is called an implied easement. An implied easement is created without a written document. Well, Rick, how does that work? There are two main situations in Texas involving implied easements. The first one is an easement by necessity. Let's say a property is landlocked. That means it's completely surrounded by other land and it has no legal access to a public road. Well, Texas courts can recognize an easement for access. Let's think about that for a second. The theory is actually pretty simple. The law doesn't want to trap a landowner with no way in and out of their property. That makes sense. Second, we have an easement by prior use. Now, here's how this one works. If land is divided and sold, and both parcels had been using a common road or a pathway, Texas courts may imply that the easement continues even after the sale. So what does that mean practically? No document, no recording, but a real enforceable property right. Now, the third type of easement is the one that really surprises people. That's what we call a prescriptive easement. If someone openly uses a portion of your land without permission, continuously for 10 years, Texas law may recognize that use as a legal easement. Let me say that again. 10 years of use can create a property right. Yes, that's Texas law. Now, this is Texas specific. If you're watching from another state, your rules may be very different. Check with the local attorney. But if you're in Texas, pay attention to what's happening on your land. And now we get to easements by estoppel. Here's the idea. If a landowner leads someone to believe that an easement exists and that person acts on it, Texas courts can hold that the easement is real, even without a document. Think about that. Promises and conduct can create property rights. Now, once an easement exists, what actually controls it? In Texas, the answer is the instrument that created it. The grant language controls the scope, the purpose, the width, the permitted use. And here's where it gets interesting. Vague language invites disputes. A right of way for ingress and egress. Sounds clear, right? Until someone paves it, until someone fences across it, until a developer wants to run utilities through it. Texas courts then have to interpret what was written sometimes 100 years ago, and the results are not always what you'd expect. So how does an easement end in Texas? Let's walk through it. First, we have what's called an express release. That means both parties agree in writing to terminate it. Simple enough. Merger. If one person ends up owning both the dominant and the servient estate, the easement disappears. Why is that? Well, because there's no one left to hold it. You can't have an easement over your own land. And then there's abandonment. Now pay attention to this one. Non-use alone is not abandonment in Texas. Let me say that again. You can stop using an easement for decades, and Texas courts have said that's not enough. There must be an affirmative act, some conduct showing you intended to give it up. That surprises people, and it surprises some attorneys. Non-use is not abandonment. Remember that. So why does all of this matter? Here's the big picture. Texas is a state where property rights run very deep. Easements touch almost every piece of Texas real estate. Urban lots, rural ranches, subdivisions, pipelines, conservation land. Think about that. If you're buying, you need to know what's burdening the land. If you're selling, you need to know what rights travel with it. If you're in a dispute, you need to know how Texas courts see it. So here's your map. We have express easements. We have implied easements. We have prescriptive easements. We have Estoppel, governed by the grant language, the written language. Ended only in specific ways, and non-use alone doesn't do it. That's Texas law in a nutshell. Every video in this series will go deeper into one piece of that map. Next, we break down dominant and servient estates, what those terms really mean, what rights and obligations attach, and what happens when those interests collide. Don't miss it. If this video was informative, please be sure to like and subscribe below. I always like to remind viewers that these videos are not meant as legal advice. If you need help with a matter, you can contact us in the links below. As always, thanks for watching.